and then I've been there 3 months, so 9 months.
His 9 months left.
Okay, we'll do 90 days. And at that time, if you'll get with Ms. Malfino the week before, and if everything's going well, we could probably do a reset without everybody having to come down.
Appreciate it.
Just let me know, but make sure that week before, talk to
Okay.
Ms. Malfino, she can check on it, and y'all just send me a message.
Okay.
All right.
Thank you, Your
sir.
Honor.
Thank you for the.
Morning, ma'am. Are you Jasmine Jaquette?
Yes, ma'am.
And this is cause number, spit your gum out in that trash can over there.
Here. All right.
This is 26 DCCR 0240. Ms. Jaquette is charged with deadly conduct, discharging a firearm. Mr. Parker?
Your Honor, we're asking for reset. I've talked to Ms. Malfino about this, and I think there's a co-defendant.
Judge, I have the co-defendants in this case, and it's going to end up I'm going to have this one reassigned to me. And so I would ask for a reset also, just so Mr. Parker can get with her about what her options are.
Okay, sounds good. So Ms. Jaquette, I'm going to reset your case about 30 days or so. Stay in touch with Mr. Parker so that once he gets with Mr. Nichols, he'll know what your options are, have all of the discovery, and you can, we'll get an announcement at the next court day.
She has actually called me.
All right, good. All right, good. We'll see you the next court day. You're free to go. Good morning. Are you Calvin Smith?
Yes, ma'am.
And Mr. Smith was previously in court in cause numbers 25 DCCR 1638 and 1639, entered pleas of guilty to those offenses. And I've received the pre-sentence report. Has everyone had an opportunity to review the report?
Yes, Your Honor.
Yes, Judge.
Any additions or corrections?
Not from the state.
All right, Mr. Smith, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. Find sufficient evidence in each case to find you guilty. In cause number 25 DCCR 1638, defer all proceedings and place you on probation for 5 years. Order that you pay the $1,000 fine and follow all of the rules and conditions of probation. In cause number 25 DCCR 1639, also, defer all proceedings and place you on probation for 5 years. You're ordered to pay a $1,000 fine in that case also, and to follow all of the rules and conditions of probation. If you do everything that you're supposed to while you're on this probation, this is an excellent opportunity because you don't have a felony conviction on your record. And at the end of the probation, the cases will actually be dismissed and you'll never have the felony conviction. The other side of that is if you violate any condition of probation, then you can be brought back into court, found guilty of the offense, and sent to the state jail prison in one case for up to 2 years, and sent to prison in the other for between 2 years and up to 10 years. Do you understand? And I know there were some issues based on this offense and when you had your wreck, and I know your mom's helping you. You need to make sure and follow all of the rules. If you need help, if you're having trouble understanding and things like that because of the injury, then you just need to make sure, have her come with you, talk to probation so that you know everything you're supposed to be doing so you don't not do something you're supposed to. Does that make sense? All right, I'm handing you in each of your cases the trial court certifications. This shows that these were agreements that I followed, so you did waive your right to appeal. You need to have a seat in the courtroom. Probation's going to call you up to her desk when she's ready to go over your paperwork. So just listen for her to call your name, okay? Good luck to you, sir. Good morning. Are you Virginia Williams?
Yes, ma'am.
And let's see. Give me just a second to get this close. Judges 2-1 rejection.
Oh, I only did one. I did, Judge. Yes.
Is it the same
Yes.
to run concurrently?
Yes.
The objection to me filling that in?
No, Judge. Sorry.
All right, so Ms. Williams, in cause number 26 DCCR 0218, you're charged with a state felony offense of theft of property with previous convictions. That's from November 25th of 2025. Your indictment alleges you were previously convicted of theft May 12th of 92, and then 3 cases, January 11th of 1994, again, October 9th of 2006, April 13th of 2011, May 2nd of 2012, October 6th of 2014. And then your indictment further alleges that you were convicted of forgery, a 3rd-degree felony, August 4th of 1995, 2 cases on that day of forgery, and then another of securing execution of a document by deception. And then after those were final, you were convicted of possession of a controlled substance, a third-degree felony, December 18th of 2017. Well, what that means is that if you go to trial and you're found guilty and all of those prior, or at least some of those prior convictions are true, you would be facing punishment as a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yes.
And I have here, and that's in both of your cases. The second case is 25 DCCR 1430. It charges theft of property with previous convictions, and that one's from August 9th of 2025. Again, with those same prior convictions listed and the same possible punishment range. You understand that as well.
Yes, ma'am.
And then I have a plea bargain rejection that you've signed with Mr. Parker that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to proceed on count one only for an 18-month state jail term in each of those cases that would run concurrently, which means together at the same time. You have every right to reject that offer and have your cases set for trial. I want to make sure you understand that before we go to trial, what your options are and what the possible consequences are if you go to trial. And do you understand all of that? And you want to reject that offer and have your case set for trial. Have both cases set for trial. Okay. I do want to also make sure you understand that after today, I will not accept this plea agreement. This plea agreement is already extremely low for the criminal history. Even though some of it's very old, it is significant. And so and it's fine, if you're not guilty of both of these offenses, then that's what a jury's for. So I'm not trying to talk you anything. I'm just trying to tell you that I'm not going to accept this plea agreement after today. Do you understand? Okay.
Just for the court to where it is that one reason it's been reset is there's supposedly people are going to sign a non-prosecution affidavit. Well, affidavits that she's not the one that did it, and she has got it signed, but it's not notarized. And I told they need to go to the DA's office. So that's the only.
And
Thank
y'all
you.
haven't had anybody come to do
No.
that?
No, Judge. I think so. This is not my case.
I cannot hear you.
This is not my case. It's for the small fingers.
Okay.
That one's really.
But she has not. No, nobody has been there.
Good morning.
On the way up, he understands what's going on. Judge, I have my assistant going to help to translate. We're going to reject the offer today.
Okay, you need to do that in writing. There's a plea bargain rejection on the tablet, and then I'll call it up, and by the time she can be up here and help me go through that and make sure he understands all of that.
Yes,
Okay,
Your Honor.
I'll hold it.
Go ahead and do it.
All right,
I'm
thank
sorry, we had a little emergency in the parking lot with a different county and a Zoom.
Okay.
deals that-
That's okay, no problem. Yeah, no
We'll
problem.
get it done, Judge. Thank
Sure.
you.
And they can, if you need some help, I'm sure one of the attorneys can.
I probably will.
Okay. Good morning, ma'am. You are Evelyn Odom. And Ms. Odom was previously here on cause number 26 DCCR 0403, entered a plea of guilty to a lesser offense of Class A misdemeanor evading arrest or detention. And I reset it for sentencing. Ms. Odom, have you been arrested for anything between when you were here to plea and today?
Yeah, ma'am.
All right, then any reason not to go forward?
No, Your Honor.
All right, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of evading arrest or detention. Sentence you in accordance with your agreement to a term of 30 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody previously on this case that the law gives you the right to receive. I'm handing you the trial court certification. That shows that this was an agreement that I followed, so you have waived your right to appeal. All right, good luck to you, ma'am. You can go back with the bailiff. Good morning. Are you Michael Sarant?
Yes, Your Honor.
And Mr. Sarant was previously in court, entered a plea of guilty in cause number 25 DCCR 1691 to the third-degree felony offense of evading arrest or detention with the use of a vehicle. I've received that pre-sentence report. Has everyone had an opportunity to review that report?
I have, Your Honor.
Yes, Your Honor, we have.
Any additions or corrections?
None from defense.
No from the state, Your Honor.
All right, Mr. Sarant, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, however, you will follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. There is a recommendation for some spinal tap treatment. I didn't really see a lot of issues with that. So what I'm going to do is just order an assessment first. And we'll have a mental health assessment done. If there's some issues that need to be addressed, then whatever that is, if there's any, you'll be required to follow whatever treatment recommendations. You understand?
Yes, ma'am.
All right. If you do everything you're supposed to when you're on this probation and follow all of the rules successfully, then at the end, this is the case will be dismissed. It's a great opportunity. You don't have a felony conviction on your record. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and you could be sent to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows that this was an agreement that I followed, so you have waived your right to appeal. You just need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork, so just listen for her to call your name.
Yes.
All right, good luck to you, sir.
Thank you.
Good morning, sir. Are you Marvin Davis?
ma'am.
And this is cause number 26 DCCR 0754. Mr. Davis is charged with injury to a child, elderly, or disabled individual. What is the announcement?
Judge, we've gotten an offer from the state that I do need to go over with my client some more. Also, he's involved right now with his payment plan and everything going on with CPS. So part of that is that we're trying to let him get a little further down for us to complete some of those classes
Sure.
before we proceed. So we're asking just for one reset.
Right. Any issues? that you-
No issue that I see, Your Honor.
All right, I'm going to reset your case, just a normal reset. It's about 30 days. Make sure you follow through with everything on that safety plan. That's only going to help you in this case as well. All right. Stay in touch with Mr. Lewis. He'll let you know when your next court date is. All right. You're free to go.
Good morning, Your Honor.
Good morning. You're Lance Charbino.
Yes, ma'am.
And this is 25 DCCR 0096. Mr. Charbino is charged with credit card or debit card abuse. And what is the announcement?
Judge, we're asking if we can set this for a plea for next week. He will be able to have that restitution by tomorrow. Should be, so we be able to have that paid before we come back.
Any issues, Mr. Nichols?
That's fine,
All
understand.
right, we'll reset it 1 week for a plea. So it'll need to be taken care of next Monday. All right.
Thank you, Judge.
She's my,
Good morning, Ms. Cantu.
Good morning.
Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes.
Thank you, ma'am. And sir, are you Guadalupe Reyes?
Yes.
And Mr. Reyes, in cause number 25 DCCR 1422, you're charged with a first-degree felony offense of aggravated robbery from May 25th of 2025. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be a minimum 5 years up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it. Before you sign this, did you go over it with Mr. Wasserstein?
Yes.
Do you fully understand it?
Yes.
It shows that if you wanted to enter a plea of guilty, that the state is offering a cap of 15 years in prison, which means you would leave your punishment up to me, but I couldn't give you more than 15 years. I could give you 15 or less. It would depend on the evidence that was shown to me at a sentencing hearing later. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Entonces usted no quiere refusar esa oferta y poner su caso para oficio.
Sí.
Yes.
All right, then we will move your case to the trial docket
Entonces van a mover su caso para oficio.
and Mr. Wasserstein will begin preparation.
Y se va a poner preparación.
Stay in touch with him. He'll let you know when you need to be back and ready for trial.
Tiene que contacto con el abogado y dejar saber cuando usted quiera esa persona.
Right?
Okay.
Thank you.
For the opportunity.
Thank you. You're free to go. All right, Mr. Hassan, you tested positive for THC. So obviously that is a violation of your bond condition. Well, what do you do that would make you test positive?
Ladies, Saturday and Sunday.
What?
Together, like family gatherings and stuff. That's it. No smoke. I don't drink. I don't smoke.
Well, you tested positive for a reason, and just being around it a little bit a week or two ago isn't going to make you test positive.
Yesterday, Saturday and Sunday.
So why, if you know you're coming to court, would you be at some family gathering where everybody's smoking dope? What sense does that make?
I wasn't thinking too much of it like in that.
So here's what I'm going to do because of that, Mr. Hassan. I'm going to require that you wear a drug patch. All right. And so you have 24 hours to get a drug patch put on. And you have to get it changed every 2 weeks. You have to make sure it stays on. There's no, it fell off or it's not testable or anything like that. If it continues to test, it's going to show me the amount in your system, not just a positive or negative. So that amount should be going down every 2 weeks. I get those every 2 weeks and I'll look at every single one of them. If it's not going down, then I'm going to assume that you're either around people you shouldn't be around or you're smoking yourself. Either way it goes, I don't care. It's going to show positive. So you cannot be around anybody else. If you think that that's what's making you test positive, then I would stay as far away from it as possible because you're the one that's going to end up in jail if it tests positive again. Do you understand? So again, 24 hours, you need to get proof of that to your bondsman. They can also tell you where you can get it. So call your bondsman. They'll let you know where you can get. There's several different places you can go get that drug patch. You have to have it by noon tomorrow. Also, you need to have an attorney before that next court date. And if you don't, you need to bring me the names of 3 new people that you have talked to. If you don't do all of that, then those are all court orders that you will have violated. And your bond's going to be raised in each of your cases and you're going to go back to jail. Any questions? All right, step in front of the clerk. Good morning. Are you Tiona Hughes? And will your client waive the formal reading of the indictment? Ms. Hughes, in cause number 25, BCCR 1058, you're charged with the state jail felony offense of debit or credit card abuse from May 19th of 2025. And how do you plead to that charge? Guilty. Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Burnett?
Yes, sir.
Do you fully understand?
Yes, ma'am.
And, oh, now I've done it. Everything just went. How did this make that go off? Sorry. Do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for how long?
3.
3's the agreement? Don't write that in, or it didn't show up. All right. So a 3-year deferred probation, there would be a $500 fine and you would be required to pay any restitution that would be determined between now and when we come back for sentencing. Is that your understanding?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, state's fine.
It's admitted. Is there any evidence that Ms. Hughes is not competent? All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, but I'm going to reset your case for sentencing so we can get a pre-sentence report done. That'll give me more information about you, your case, and then we'll also get that restitution figured out between now and when we come back for sentencing as well. On your way out of the courtroom today, you need to stop and talk to probation. She's at that desk right over there, and she'll get that process started.
Is there way possibly the court would consider waiving the BSI and having it determine if there's a problem?
I have to order the restitution. If y'all knew the restitution amount, I could, but not without knowing it. Yeah. All right. We'll see sentencing. Ms. Robertson, in cause number 25, DCCR 1526, you're charged with the state jail felony offense of forgery of a governmental instrument from June 4th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Burbank? Do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 5-year deferred probation. Does not look like there's a fine, but there would be restitution that would be determined between now and sentencing. Is that your understanding?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection, statesman.
It's admitted. Is there any evidence that Ms. Robertson's not competent?
No.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case. Also give them time to figure out the restitution amount, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. Okay, we'll see you back at sentencing. Good morning, you're Deanna Paul.
Yes, ma'am.
And this is 25 DCCR 1792. Ms. Paul's charged with stalking, and what is the announcement?
Your Honor, I visited with the prosecutor. There's been some additional evidence that's come forward that may impact the case. It will be, it's not going to be a trial, sure. But it could impact the outcome of the case. I've spoken with the state and we're in agreement. He says he's in agreement with your approval. We just need one more setting.
Okay. All right, no issues. All right, this will be the final reset. So Ms. Paul, make sure that you stay in touch with Mr. Samuel, go over everything, anything that's new. If there's something you need to get to Mr. Smith, do that quickly. And we'll get a plea at that next court date.
We'll do that.
Okay, thank you. You're free to go. All right, sir, you're Henry Littlefield. Answer
Yes,
out loud,
ma'am.
please. Thank you. And this is 26 DCCR 0395. Mr. Littlefield's charged with driving while intoxicated, 3rd or more. And this is Ms. Malfino's. Any notes or anything that would help?
Judge, I didn't see anything that would answer its question today. So and I don't see any problems for a reason not to reset if it's okay with the court.
All right, I'm going to reset it one more time. I know she's on vacation this week, but make sure you call, get it,
Yes,
see her as quickly as possible. And Mr. Littlefield, you have the auto ignition interlock device on your vehicle?
No, ma'am.
Are you driving?
No, ma'am.
Okay, so as a condition of your bond, I want to make sure that we're on the same page. You either do not drive or you have to have an auto
Yes.
ignition interlock device.
Uh,
Okay, all right. Anything else then?
Nothing I'm aware of. Your Honor.
All right, we'll see you back at the next court date.
Thank you,
Thank
Judge.
you. I was informed. Good morning, ma'am. You're Kristen Bell.
Yes, ma'am.
And this is 25 DCCR 1812. Ms. Bell's charged with injury to a child, elderly, or disabled individual.
Yes, Your Honor.
Announced.
Your Honor, I spoke with Ms. French. There may be a change in the offer due to some additional information that she has been given that I'll make time to discuss Ms. Bell if possible.
All right, any issue with the reset then?
No,
Ms.
Your
Bell?
Honor.
So Ms. Bell, I'm going to reset your case about 30 days. Make sure you call and make an appointment. Go visit with Ms. Holmes before that next court date, and we'll see if we can get an announcement. All right, you're free to go.
Judge, Ms. Bell has a warrant.
Oh, I'm sorry. Okay.
Right here for a second.
It's my understanding she has a municipal court traffic ticket warrant. Is it possible that she can go
I
take
can't.
care of it?
No, I can't give her permission. If there's a warrant, we have a requirement or they have a duty to take her in.
Okay.
Yeah, there's nothing I can do with regard to that warrant. It's not mine.
Okay.
All right.
It'll be a while before she's transported if you want to try to.
Yeah, it's
If
Beaumont
somebody-
Municipal Court.
If somebody can take care of it while she's still here.
I don't have nobody else supposed to do it.
You know how much the ticket is?
It wasn't normal, I think, when it went.
Y'all go, take care of that back there, please. Good morning. Are you Francisco Garcia?
Yes.
And Mr. Garcia was previously in court, entered pleas of guilty in cause numbers 25 DCCR 0900 and 0901. I've received the pre-sentence report. Have you both had an opportunity to review the report?
Yeah, sure.
Yes, Your Honor, I have.
Any additions or corrections?
Not from the defense, Your Honor, we are asking that, the court, grant the 5-year deferred probation.
All right, Mr. Garcia, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily. In cause number 25 DCCR 0900, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made and defer all proceedings and place you on probation for 5 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. In cause number 25 DCCR 0901, also find sufficient evidence to find you guilty, but I'm going to follow the agreement in there as well and defer all proceedings and place you on probation for 5 years. You're ordered to pay the $500 fine and to also follow all of the rules and conditions of probation. Part of that is going to be that you at least start off on the high medium caseload, which means you're just going to have to go a little more often, get on the right track. You will have no contact at all or communication in any way with Melissa Escalera or Jose Bravo Landa. That means obviously in person, but it's through any other means, electronic, Snapchat, DMs, text messages, whatever. Okay. You can't go where they live, where they work, nothing. Also, you are ordered to delete and destroy any images that you have on your phone of her, and that you will also be required to allow probation to go through your phone and look through all of that to make sure that that has happened. You understand? If you do everything you're supposed to on this probation, these are probations. These are excellent opportunities because you do not have felony convictions on your record. And if you successfully complete the probations, the cases will be dismissed at the end and you'll never have a felony conviction. The other side to that, though, is if you violate any condition of your probation, you can be brought back into court, found guilty in each offense. And in the burglary of a habitation, you could be sentenced between 2 years and up to 20 years in prison. And in the publishing or threatening to publish intimate visual material, you could be sentenced between 6 months and up to 2 years in a state jail prison. Do you understand?
Yes.
I'm handing you the trial court certification in each of your cases that shows that these were agreements that I followed, so you have waived your right to appeal. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go for your paperwork. All right, good luck to you, sir. Good morning, sir. Are you Michael Morgan?
Yeah.
And Mr. Morgan is charged with theft of property with previous convictions and cause number 24 DCCR 0590. And what is the intent?
Your Honor, I've been having trouble with the discovery, and Mr. Smith looked as well as the videos. It's alleged theft from Walmart, and the videos were not working for me. Mr. Smith tried to, they're not working for him. And Mr. Morgan would like to see what's on video. So that's the hiccup we've run into. So we are trying to get with Miss Mayfield upstairs to see if they can figure out a way to get these videos working. And also Mr. Morgan was in the hospital yesterday from a apparent mild heart attack, possibly. This is records that the hospital gave, and he probably needs to go back. He released himself out because he knew he needs to come to court. He didn't want to have a warrant. So
Okay.
that's the other issue, but the biggest one is
So,
I don't know.
well, I guess I'm looking back. It looks like it was pending and then he wasn't actually arrested on it for
Oh,
2 years. The warrant was issued back in 2024. And then it looks like it got returned in February 2026. Okay. All right. Let's just do a normal reset. And that'll be about 30 days to give y'all some time to see if you can get that working, if it exists. If it doesn't, then we'll just need to go forward with what you got.
yes,
But
yes.
we'll hold it for that. I mean, I'll reset it for that.
Okay.
Stay in touch with Ms. Holmes. She'll let you know when you need to be back, sir. All right. You're free to go.
Thanks.
And then you've got Aaron Riley. Right, good morning, ma'am. Are you Erin Riley?
Yes, ma'am.
And this is 25 DCCR 1192, and Ms. Riley's charged with assault of hospital personnel. And what is the announcement?
Your Honor, the same, we provided some, medical records to, the prosecution.
And that's where today's courtroom drama comes to an end. What started with simple instructions quickly turned into serious consequences, proving just how fast a defendant's situation can change inside a courtroom. From a $100,000 bond increase, to probation violations, to strict conditions involving family and children, every decision carried real consequences. But here's the bigger question: when a judge gives someone another chance, how much responsibility should the defendant have to prove they deserve it? The courtroom doesn't run on excuses, it runs on accountability, evidence, and compliance with the court's orders. What would you have decided if you were sitting on that bench? Let me know your thoughts in the comments, and don't forget to like, subscribe, and stay tuned for the next courtroom breakdown.